Recorded conversations are very, very compelling, very, very powerful, and can be very exculpatory. Because it's really the jurors peeking in and the court peeking in at a very private, intimate discussion, especially with a loved one, the family member, with a wife. It's almost like you can get a very compelling confession. Do you remember in The Grapes of Wrath, the protagonist, Tom Joad, when he goes up to her and says, "Mama, I've done something real bad. I got to go away for a while, Mama. I've done something real..." When you can hear that, with everybody's guard down, it's very, very compelling. You know, I've been doing this for 25 years, and they've been recording conversations for 25 years, and this evidence never really came in. But now the technology is so great, the technology is so sophisticated, they can get these telephone records in a heartbeat. And I'm telling my clients now more and more, they really are listening, they really are recording, and they really will bring into court what you have to say.
All right, Beth.
Yeah, I agree. I think the prosecution has to be careful here. What they're doing is taking otherwise good pieces of evidence, the neighbors, Ed Klug and the others, and also they're just polluting this courtroom with these snitches, and they're absolutely humiliating that wife. I mean, there's a danger here. They've got to have her on there, and they've got to ask it. But think about it. In a jury trial, the jurors feel sorry for almost any witness up there, and they're taking that woman with poise and absolutely humiliating her. Cunnilingus and sexy emails. And the prosecution risks here losing the emotional battle with the jury here, because the defense is going to stand up and say, look what they've done. And then they try to beef it up with these guys who are easy to pick on. I mean, con man, thief. And what the lawyer will do is stand up behind the prosecutor and say, you're going to have this prosecutor come into your trial and tell the judge what a good person you are and that you should get a lenient sentence. I think they've got to be careful. They can overplay those snitches. They really can.
The details. Alex Flynn, is this stuff, at this point, is this stuff still relevant to the case?
I think it goes to motive. I think it goes to anger, to jealousy, to floating his boat. For whatever reason, this woman really excites him, and really he's attracted to her. And remember something, she's testifying under a grant of immunity. She took the Fifth Amendment privilege against self-incrimination at the outset, and the judge ordered her to testify, and I don't know if it was the use immunity or use and fruits immunity or transactional immunity. I thought I heard him say transactional, but she has to tell the truth. I think that's the only thing for which she could be prosecuted coming out of this. She has to go up there and tell the truth, and I believe it was transactional immunity. But yeah, it's relevant. It goes to anger, jealousy, obsession, why he wants to be with this woman, and why he might have a motive to do something wrong.
All right. So, Alex, what should we read into the fact that she got immunity, that she knew something that was incriminating, that this guy is guilty, that she knew her husband was guilty?
No, remember, the privilege against self-incrimination is a privilege not to be forced to testify against anything which might tend to incriminate you. This has gone on for 10 years. There might have been a statement made that might have been a little false that was obstructing. There might be some bizarre allegation of aiding and abetting a felon after the fact or something like that. So her lawyer came in and said she's not going to say anything. And at that point, the prosecution under Wisconsin law has the right to move the judge and say, order her to testify. Well, once you order her to testify, then it's compelled, and then she's immune from any prosecution that comes out from that, except for perjury. She cannot perjure herself. So I think it's a cautious and good defense lawyer that she had on her behalf, saying she's not going to say anything, Judge, unless she gets immunity, because this prosecution we don't trust, and we don't know what they're going to do after this.
All right, Alex Flynn, always great to have you.
Aberration. All right, let me go out to Alex Flynn, our colleague who is in Wisconsin, there with Gene Casares. And Alex, ask you about, of course, it's early on in the cross, but how do you think it's going, and where do you think he needs to go next?
Well, I think what he's got to do is, and I think he's got to establish the timeline, which I think they're doing. That is that the state has come up with the time they believe she died. It's a window of about an hour. Whenever that happens, there's always opportunity then for the defense to look backwards and say, where was he the hour or two before that? It's a Thursday. There's meetings there. He's at work potentially. He's meeting with a client. There's cell phone records. So he can establish that he couldn't have been around to do what Aaron Dillard says he did. Because remember, one of the stools of this prosecution's, the state's case, is one of the legs of that stool is Aaron Dillard. And it's going to be pretty easy to knock that stool out. So if he can establish, and the prosecution's got to think about this, they've got to refute and show that he had access for the hour or two or three before that, before rigor mortis started setting in. That's where they've got to go with it. But then, of course, he's doing what he should do. He's got a whole treasure trove of documents there, and he can pull out one nugget after another nugget after another nugget. And what people should understand is it appears to be hearsay, but if an expert relies on that material and that information to form her opinion, then it's not hearsay and it's all fair game.
Thank you so
I agree with you, and I agree with you, Jamie, that I think he overall, from what I've seen, is doing a pretty even-handed job here. Pretty fair. He's being equally harsh with both sides and equally fair with both sides in terms of objections and evidence. Remember, the state did not give the defense lawyer the statement before, and he kind of admonished the prosecution about that. But I think the jury is out on the judge till this is over. I know it's a 10-year time frame we're looking at here, but a judge has to keep a handle on it. If this thing is going to go on 4 weeks, 6 weeks, 8 weeks, and he's got to keep control of that and not let it go out of hand. On the other hand, he's got to weigh it against. There's 10 years of evidence here.
Yeah.
So the jury is out on the judge, but overall, I think he's doing an excellent job.
And some